Thank you for joining us. We are very excited about today's webinar and glad that you joined in with us. This webinar is presented jointly by SCRA, the South Carolina Research Authority, and the Kim and Leahy Law Firm. And I must say that it is through Doug Kim that we actually got connected to our speaker today, who is Elizabeth, Doherty. And when Doug Kim said, you really need to meet Elizabeth and understand what she does. And so we're going to learn more about that today. But I do want to tell you that today's session is being recorded. You will have an ability to get a recording and also the slides that Elizabeth is going to be using. We encourage you to submit questions along the way by using the chat button at the very bottom, and we will respond to those. And I am telling you, this is a very important webinar, and to tell you how important it is, I'm actually wearing a sport coat for the first time in about a year because of COVID. But I told Elizabeth a little earlier, this tells you the elevation that we have given this webinar. I must tell you, when Doug Kim said you really need to meet Elizabeth and understand that she is the Eastern Regional Outreach Director and head of stakeholder engagement for the U.S. Patent Office. Number one, I didn't know such an office existed. But after we got on the phone and heard about her mission and her office's mission, we said, wow, this is a great opportunity for organizations in South Carolina to learn more, to learn directly from what they do. And it is such an honor to not to talk to someone who is translating from the Patent Office, but actually to talk directly to the Patent Office directly. And so with that, I would like to introduce Elizabeth Doherty. And we are thrilled that you are with us today, and we look forward to your commentary and your slides. And again, I would encourage everyone who is on to do not take furious note, because all of this will be available to you both in a recording and a copy of her slides as well. So with that, Elizabeth, I'm going to turn the floor over to you.
Good morning, Steve, and thank you. Thank you for that kind introduction. Thank you to Doug Kim for making the introduction of the U.S. Patent and Trademark Office Eastern Regional Outreach Office to you and your team there at the South Carolina Research Authority. We welcome this opportunity to collaborate and this unique opportunity to talk about the role and importance of intellectual property, to talk about some of the misunderstandings, and perhaps to help demystify the process. Through this series together, I hope we're going to be able to really encourage and incentivize people to protect their intellectual property, because it is so very important. We know for all too many people that protecting their intellectual property is a rainy day project. It's that project you're going to do when you have more time, more money, or just simply when you get around to it. And unfortunately, oftentimes by delaying in protecting your intellectual property, you're precluding yourself from protecting your intellectual property. As Steve said, my name is Elizabeth Doherty, and I serve as the U.S. Patent and Trademark Office's Eastern Regional Outreach Director, which is really just a very long way of saying that I help people. And I specifically help stakeholders using the USPTO products and services, stakeholders that are positioned in the 17 states of the East Coast and including the District of Columbia and Puerto Rico. My team and I work with stakeholders every day of the week, and we love what we do. I'm a 30-year veteran of the U.S. Patent and Trademark Office, having started my career as a patent examiner, working in the exciting and sexy art of Class 73 measuring and testing electrical mechanical devices that measured or tested. So that could have been torque transducers, flow meters, pressure transducers, meteorological devices. really good stuff, but a great way to introduce myself into the world of intellectual property, and something that has really helped to help me work with inventors and innovators now on a daily basis. And this has really been the joy of my career, to do this outreach work, to again demystify the process, to help encourage and incentivize people to protect their intellectual property. So with that, and without further ado, I'm going to jump right into the materials we have today. As Steve said, these slides will be provided to you, and I got to warn you, there's a lot of them. Because at the U.S. Patent and Trademark Office, we believe that more is more. So we've got a lot of slides today. We'll get through them, but I do want to encourage your questions along the way, and we'll try and save some time for questions at the end. I also encourage you to reach out to me on LinkedIn and to reach out to me by email if we're not able to get to your question today. But with that, we are going to go ahead and jump into our materials. I'm going to put these slides up for our use. And here we go. So today, what are we going to cover in our time together? Well, here's what we hope to accomplish. I know it's a lot to fit into in an hour, but we're going to see if we can do it. We're going to talk about what is intellectual property. And I recognize that some of you, if you've already participated with the SCRA, you may already be exceptionally knowledgeable about the importance and the role of intellectual property. But for those of you who are not comfortable or knowledgeable about intellectual property, this is going to be a great opportunity to get your feet wet and to start understanding some of the concepts, some of the terms, and again, what is intellectual property? We're going to talk about what is the U.S. Patent and Trademark Office, because unfortunately, we are one of the government's best kept secrets. Now, perhaps that's great that we're not on the front page of the Washington Post every day, but it also makes us aware that we need to be better about educating the public about the role of patents and trademarks. We're going to talk about the 4 basic forms of intellectual property: patents, trademarks, copyrights, and trade secrets. We're going to do a deeper dive in the area of patents, and then we're going to talk about some USPTO resources. We have a wealth of resources that are available to our stakeholders, many of which are free, the majority of which are free, but oftentimes because our website is so rich with resources, people aren't always aware of all of the initiatives, programs, and opportunities available to folks using our products and services. So what is intellectual property? Let's start there, because this really is an introduction to intellectual property. So you may have heard of intellectual property. You may have heard the term or the reference to IP. That's what we're talking about today. Now, if we think about real property, all of us are very well aware of what is real property. Real property is that house, that car, that boat, those things that you own, that you possess, you've purchased, you've leased, you've borrowed. They can be sold, they can be given away. They are those things that you signed on the dotted line. Well, intellectual property, juxtaposed to real property, but yet very similar, is property of the mind. It is creative property developed by the mind of yourself and a team. And again, it is something which, like real property, can be protected. It can be bought, it can be sold, it can be given away. So today we are not focusing on real property, but we are focusing on intellectual property. Now, why should you care about intellectual property? Well, if we look at it from a 30,000-foot level, we look at it from the level of why is it important to us as a nation? Why is it important to us globally? IP-intensive industries are critically important because they are industries which produce jobs, and they produce jobs that are higher paying jobs. In fact, 46% higher pay. Now, when we say an IP-intensive industry, we're meaning an industry that has been built by companies that are using intellectual property. They are using patented technologies. They are using trademark indicators of goods and services. They have built an IP portfolio, which has provided value in that company. These IP industries built of these companies built upon intellectual property also produce a wealth of our gross domestic product. In fact, 38.2% comes from IP-intensive industries. Now, if we were to take that down a level, down from that 30,000-foot level, down to the level of why is it important to you as an individual? Why is it important to you as an inventor, innovator, entrepreneur? Well, for some of the same reasons as why it's important to us as a nation, but it's also because it is attractive to investors and buyers. Keep in mind, like real property, it can be bought, sold, licensed, given away. For any of us who's ever watched an episode of Shark Tank, invariably, what is one of the first questions the sharks always ask that person coming before them? Do you have a patent? Do you have a trademark? Do you have an intellectual property portfolio? Because it makes it attractive to them as investors and buyers. By protecting your intellectual property and putting the public on notice that you have protected it, it can help to deter infringement lawsuits. By letting people know that you have patented this technology, that you have trademarked this brand, you are alerting others to stay away, to exclude them without your permission. By having intellectual property, you can also increase the leveraging power because, again, keep in mind, intellectual property adds value to a company, to an individual. It's a property right that can add value at the company's bottom line. Again, it can be considered when evaluating the value of a company, whether you're looking to grow, you're looking to merge, you're looking to sell. And IP is also global. So what is the U.S. Patent and Trademark Office? Well, I'm very proud to tell you it is one of America's oldest federal agencies. In fact, the first patent law was passed in 1790, and the work of the U.S. Patent and Trademark Office is in fact within the U.S. Constitution. Both the work of patents, trademarks, copyrights are all recorded within the Constitution because our founding fathers knew that in order for us to grow and be a strong and industrialized nation, we were going to need to protect the creative discoveries and writings of our inventors and authors. So we, again, the first patent issued in 1790, along with that first patent law in 1790. We are today currently an agency of over 13,000 employees. We're all still teleworking due to the pandemic, but we hope that that will change very shortly. We issue US patents and we federally register US trademarks. Oftentimes called America's Innovation Agency, we foster innovation and economic growth by the protection of intellectual property, and we create a reliable, predictable, and high-quality IP system through all of the initiatives, programs, and quality systems that we have put in place for use by our patent examiners, for use by our trademark attorneys, and for use by our stakeholders. While this snapshot I'm showing you right now is slightly out of date, this is from fiscal year 2019, it does give you a glimpse into the U.S. Patent and Trademark Office. As I said, we have over 13,000 employees now, predominantly positioned within our patent examining core. We have over 8,000 patent examiners today, and in fact are hiring. We're hiring hundreds right now. So if any of you have a STEM degree and are interested in working for your country and protecting the rights of intellectual property, please visit our website. Each year we receive over 650,000 patent applications and issue over 370,000 patents. Similar numbers in trademarks, over 650,000 trademark applications, and those are going through the roof right now. And we issue nearly 300,000 certificates of registration. So leave it to say, we are a very busy agency. And we know that in fact, South Carolina is very active in the process. We know that last year alone, over 1,500 applications were filed for US patents, and nearly 1,500 patents were issued to residents of the great state of South Carolina. So we appreciate that, and we welcome you to continue to be frequent flyers with the US Patent and Trademark Office. Today, we're going to look at the patent process overview through a series of steps, beginning first with what type of IP protection you need. So you may or may not need a patent, but let's talk about that next. So determining the type of intellectual property you need. This is where we're going to discuss at a very high level to start building these concepts of what is a patent, what is a trademark, what is a copyright, what is a trade secret. Patents and trademarks, as the name US Patent and Trademark Office suggests, are protected by the US Patent and Trademark Office. They are rights issued by the USPTO. Copyrights are handled by the U.S. Copyright Office, which is a part of the Library of Congress. Trade secrets are protected by the Uniform Trade Secret Act and oftentimes protected by state law or by contract law between an employer and an employee. As you can see from this chart, patents, trademarks, copyrights, and trade secrets, the four basic forms of intellectual property, protect four very different things, and they also last for very different durations. And you'll see that in the next slide. Patents protect inventions. They protect new and inventive ideas. So when we think about inventing a new bicycle, a new mousetrap, a new chemical composition, you are going to be seeking a patent to protect that new and inventive idea. Trademarks are identifiers of the source of goods and services. They are that brand recognition. They are how individuals distinguish your goods and services from those of your competitors and others in the marketplace. Copyrights are a creative expression, a creative work of authorship that has been stored in a tangible form. Think of music, think of literary works, think of sculptures, artistic works. Even dance can be placed into a tangible form and receive a copyright protection. Trade secrets are any information that is valuable and kept confidential. And when we say information that is valuable to a business that is maintaining that trade secret. Now, of course, a trade secret, the value there is in maintaining its secrecy. And we'll talk a little bit more about that. So as I said, there are 4 basic forms of intellectual property, but we can also take the patent aspect and break it down into 3 different types of patents: utility patents, design patents, and plant patents, all which protect very different types of invention. The utility patent protects what we generally think of when we think of inventions. Again, whether it's a cell phone or a bicycle or a mousetrap, it is most likely going to be protected by a utility patent, which protects the actual function of the device. It protects processes, machines, articles of manufacturers, compositions of matters, and improvements thereon. Design patents, distinctly different from utility, protect the ornamental appearance of an article of manufacture. Now, what's important to know is that in protecting an invention, you may in fact seek to have both of these forms of intellectual property in your IP portfolio, in your intellectual property portfolio. If you think about your cell phone, again, whether you have a Samsung or an Apple, there are hundreds, if not thousands, of patented technologies that are in that single phone. It is probably also most likely protected by a design patent, which protects its appearance. And maybe there are additional design patents protecting some of the icons of the apps that you have, potentially. Plant patents protect newly invented strains of asexually reproduced flowering plants, trees, and other hybrids. Copyrights, as we said, protect original works of authorship, trade secrets, and then, of course, trademarks. What I would draw your attention to in this highly dense chart is not only that these different forms of intellectual property protect very different things, they last for very different durations. Utility patents, 20 years, plant patents, 20 years. From the date of filing, design patents, 15 years from the grant of that design patent. Copyrights have a very extensive life term. It is the life of the author plus 70 years. So the author, the creator of that original work of authorship, gets to enjoy the benefit of their creation, as do their heirs. Trade secrets are a very unique form of intellectual property that can last forever if they continue to provide value to the business, if they can be maintained as a secret. So incredibly valuable because they have such a potentially long duration. Trademarks additionally can also have an exceptionally long duration because they can be continually renewed on a 10-year basis if that mark is continually used in commerce. So again, an incredibly long duration potentially. So let's talk a little bit more about trade secrets, and we're going to work our way down to patents. Trade secrets, as we said, are things which can bring value to a business if they are maintained in confidence. So it's a wide array of things. You see 2 examples here. The KFC recipe, who knows what makes that chicken so delicious, and the Google search algorithm. How is it that when you put in a few simple keywords, Google returns results that oftentimes are incredibly pertinent to whatever it is that you're researching at the time? Those are both incredibly valuable trade secrets. Now, trade secrets can also include things like formulas, customer lists, recipes, as we've said with KFC. There's a wide array of things that can constitute a trade secret. However, it has to be maintained in secrecy. So many of you may have seen or even visited in Atlanta, the wonderful world of Coca-Cola. There they have a vault, which they claim contains the secret recipe to Coca-Cola. Now, whether that vault's the real vault that actually contains the recipe, I don't know. But obviously, what they are suggesting is that they have taken great steps to maintain that recipe in secrecy. So how does one lose a trade secret? Well, there are several ways, but here are some simple examples. So keep these in mind if you are thinking about protecting your intellectual property using a trade secret. You must take adequate steps to prevent disclosure. So whether that's having a contract with the employees, whether that's divvying up the recipe so no one employee has all of the ingredients of the recipe, you must take adequate steps. Whatever those steps are, they must be adequate to prevent disclosure. Owner or owner authorized disclosure. Sometimes you may determine that you do want to disclose it, or you may disclose it accidentally. Reverse engineering, of course, can happen. I once had a conversation with some young inventors who had invented an incredibly useful device for use in developing nations to deliver saline solution to individuals in a hospital. It was a very simple mechanical device, knowing the situation and environment it was going to be placed in. However, they thought they might want to protect it by a trade secret. Now, knowing that it was a very simple mechanical device, not one which would probably lend itself to a trade secret. Anyone could have easily seen that device, figured out how it operated, and re-engineer it themselves. Again, so keep thinking about reverse engineering. Make sure that you have some component that cannot be reverse engineered. And then, of course, independent development can always take place, which could, in fact, cause a loss of a trade secret. Someone simply deciphers your recipe on their own, just through their independent development, through their use of working with different recipes or working with different ingredients. They happen to land upon your recipe. Let's talk about copyrights. So as we said, copyrights are work of creative authorship which has been placed in a fixed intangible medium. There are things like songs, movies, books, sculptures. Copyrights are incredibly unique, not only because they're so creative and they're things that we love and enjoy, but because copyrights are also what we call self-authenticating. By merely placing that creative work of authorship in a tangible medium, whether it's on a piece of paper, a CD-ROM, a thumb drive, or in the stone of a sculpture, you are in fact availing yourself of a copyright. Now, you do have the opportunity to register that copyrighted work with the US Copyright Office at the Library of Congress, and by doing so, you are availing yourself of additional protections and opportunities to protect and enforce your copyright. So again, you achieve a copyright. So in fact, all of us who are participating in this program today own several copyrighted works. If you've ever written a letter, a poem, a song, now, there is a certain level of creativity that is required. There was a court case many, many years ago regarding phone books. And did phone books have the requisite creativity to be protected by copyrights? So as we said, they're protected by the Library of Congress, and they're original works of authorship. They can be literary, dramatic, musical, artistic, and other certain works having that requisite level of creativity. So let's talk about trademarks. Trademarks are the indicator of the source of goods and services. So when we look at these examples, and trademarks can be words, they can be designs, they can be combinations of words and designs. When we see the name, the word Starbucks, what immediately comes to mind? For most of us, if you're a coffee drinker, you would quickly know that Starbucks refers to a coffee source, a location, a source of providing coffee products, beverages, and the like. When we see the term Nike, or we see that Nike swoosh, which has become synonymous with the company Nike, we know that there is something related to athletic footwear, athletic apparel, something having to do with athletics. Target. Of course, we all have come to recognize Target as one of our stores where you can get a wide variety of products. Now, there are also things as called non-traditional marks. So where words and designs are our more traditional trademarks, you can also achieve a trademark through use of a color, where that color becomes so ubiquitous that everyone knows you simply by the color. If any of us were to get that lovely gift box on the left side of the screen, we would all know we were getting something super special from Tiffany's. That Tiffany Robin's Egg Blue box certainly denotes the indicator of the source of those goods and services. UPS, what can Brown do for you? In the green of John Deere, of course. Some additional non-traditional marks include scents. Play-Doh. If somebody were to open a can of Play-Doh under your nose and you were blindfolded at the time, I think the majority of us would be very quick to call out that who's opened the Play-Doh? Who's got the Play-Doh out today? Is it time to play? There are also non-traditional marks that are sounds. Think about the giggle of the Pillsbury Doughboy or the NBC chimes, for example. Now, before we jump into patents, I do want to say with respect to trademarks, the majority of companies may or may not be using or creating something that can be protected by a patent. However, the majority, if not the entirety of companies, individuals starting small businesses, developing industries, have something that is protectable by a trademark. So oftentimes, I think trademarks are sitting on the sideline, people thinking patents are most important. However, don't disregard the importance of a trademark. You want consumers, when they come to the marketplace, to look for your goods or services. Again, whether it's a bicycle, a cell phone, or a mousetrap, you want them to be looking for your brand on the store shelves, and you want them to recognize your brand and the quality that you have built into your brand. So trademarks are incredibly valuable. So I want that to be sure to be a takeaway from our conversation today. But let's talk about patents, and we're going to spend a little bit more time in depth talking about patents today. So patents are, of course, one of the 4 basic forms of intellectual property, and they are a property right granted by the United States government to an inventor. Now, when we say an inventor, that could be a single inventor, that could be a group of inventors working together as an inventive body. One of the beauties of the US patent system is that no one is too old and no one is too young to be an inventor. We welcome inventors from all diversities and all walks of life. And in fact, we have a program ongoing right now called Expanding Innovation, where we're trying to incentivize and encourage everyone to see themselves as inventors, innovators, and entrepreneurs, no matter what your diversity is, because we really need more people to join the innovation ecosystem. So the grant of a patent to an individual, to a group of inventors, is the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention for a limited period of time. And that's in exchange for the inventor disclosing their invention with such specificity that others can make and use their invention. We have what we call a quid pro quo system, a this for that system. So in exchange for the inventor disclosing their invention so that others can benefit from it, we are willing to give that inventor the opportunity for a limited period of time to exclude others. Now, once that period of time, that limited period of time, which as we know for utility patents is 20 years, once that period of time is up, that patented technology goes into the public domain and anyone can make and use that invention without the inventor's permission. I think it's important to note right here and now as well, because I do get this question frequently, you cannot renew a patent. So when your patent time is up, your patent time is up, and the information becomes, again, part of the public domain. So again, that intellectual property right is a quid pro quo because inventors have a decision. Inventors could keep their invention secret. They could protect it by their trade secret and just enjoy the benefit of the invention themselves. But we want to encourage our inventors to make our world a better place. We want to encourage them to disclose it so that we can all enjoy the benefit of what they have created. So why get a patent? Why not keep it secret? Well, there's a lot of reasons to get a patent, and we have 4 simple examples here. 1, it can help gain entry into a market. And this goes back again to the Shark Tank conversation, or if any of you have ever participated in a trade show. Oftentimes, investors and buyers or people who are looking to perhaps bring your product into their marketplace, they're going to ask what your intellectual property is. It can also work to exclude others from a market by, again, putting people on notice that you have protected this intellectual property. You can protect from infringers and others working in the space of endeavor where you have created and protected. It can be used as a marketing tool, And like we said, like real property, it can be sold, it can be licensed, it can be given away. Now, I'll give you another great reason to get a patent, and that is for personal and professional satisfaction. My father has a patent, and while that invention was never manufactured, my father to this very day is still extremely proud of the fact that he was the first sole individual to come up with this invention, and he still has that patent on his wall. So I know, again, from personal experience that having a patent can be a great level of personal and professional satisfaction. So in getting started in the patent process, one needs to determine if your invention is in fact patentable. Is it eligible to apply for a patent? And this falls into what can be patented. So we can patent any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. So again, there are classes of invention: useful processes, machines, manufacturers, composition of matter, or improvements on any of those. If one were to look at the patents that are issuing today, and we recently, just this month, issued patent number 11 million. I'm sorry, I think it happened in May, in fact. Patent number 11 million. If we look at the patents that are issuing, 99% of those patents are issuing to improvements on existing technologies. Arguably, only about 1% of patents are to truly disruptive new technologies that no one has ever seen or heard of. That doesn't make improvement patents any less valuable, because that is one of the beauties, again, of the US intellectual property system. By creating this huge repository of technological information, we allow the inventors of today to stand on the shoulders of the giants that came before them. So as we said, what can be patented? What cannot be patented? You cannot patent laws of nature, physical phenomenon, abstract ideas, literary, dramatic, musical, and artistic works, because again, of course, remember that latter one, those are protected by copyright, and you cannot protect inventions which are not useful or offensive to public morality. So when we say not useful, one of the requirements for patent eligibility is that an invention have a utility. Now, to go to the concept of abstract ideas, people oftentimes ask me the question, well, now, if you can't patent an idea, do I have to have a working prototype? And the answer is no. Your invention could be solely reduced to your patent application on paper or electronic medium. You do not have to have a working prototype, but what the idea is that you cannot patent an idea, I'm sorry to make that confusing, is that you have to be able to, in your patent application, describe your invention with such specificity that others can make and use it. And to give you an example, I love the idea, and I have the idea that I would like to create a time machine. I'd love to create a time machine because I'd love to go back in time and meet fascinating people like Abraham Lincoln and Harriet Tubman. Now, do I have an invention? No, I have a mere idea, because I do not have an invention which I have such possession of that I can describe with specificity for others how to make and use it. So I could not apply for a patent on a time machine. Now I could, but it would be a waste of time and money. So how do you know if your invention is patentable? Well, one of the things we strongly encourage is you to have a prior art search conducted. And that's one of the wonderful things about the patent and trademark resource centers that we have across the nation. There's over 80 of them located nationwide. And in fact, there's one in the South Carolina community located at the R.M. Cooper Library at Clemson University. These libraries have librarians who are gifted in patent and trademark searching and can help you to conduct a patent or trademark search. Now, keep in mind, you are not required by law to conduct a patent search. In fact, you're going to pay your patent examiner to conduct a patent search. But we do encourage people to save themselves the headache, the heartache, and the financial outlay. Your idea may be just so good that somebody's already thought of it. So what kind of patent do you need? Well, we've already touched on the fact that there are three basic types: utility, design, and plant. So determine what it is you are trying to protect. Do you have that new and useful process, machine, article of manufacture, or composition of matter, or an improvement thereon? Or do you have something that you are protecting the ornamental appearance? Now, you may also be inventing in the area of plants, which, while it's our smallest area of inventing, it has really transformed our world. Nearly every poinsettia plant, fruit tree, ornamental rows are all protected by plant patents. Utility patents, as we know, protect the function of the invention and are good for 20 years from the date of filing. So in getting ready to apply, there's several things to know. So there are two different types of patent applications. And I stop here for a second for a word of caution. When we talk about types of patents, we know there's utility, design, and plant. All too frequently, I hear people say, oh, I have a provisional patent. Well, unfortunately, there is no such thing as a provisional patent. There is a provisional patent application, and it is a very, very useful tool. And I encourage people in the right circumstances to use a provisional patent application to get something on file with the US Patent and Trademark Office. However, the words of caution here are that the provisional patent application is merely a placeholder. It's a one-year placeholder you can file with the US Patent and Trademark Office with a low cost of entry and a low barrier of entry requirement-wise, but it is only good for 1 year. It is maintained in confidence, it is not examined by a US examiner, but it does not result in a US patent. If one is seeking a US patent, you ultimately have to file a non-provisional patent application. That non-provisional patent application will be published at 18 months. It is what is picked up by a US patent examiner and can result in a patent. Now, the provisional application is great and used very frequently, particularly oftentimes by startups and entrepreneurs who want to get something on file, because by putting a provisional application on file, you can begin to use the term patent pending, and you can begin to talk to others with some level of specificity about your invention because you have something on file with the office. However, it is only that non-provisional application that will result in a US patent that you can in fact enforce against someone who you think may be infringing upon your invention. Here is a quick snapshot at the utility patent fees, just to give you a ballpark for what are you getting yourself into as you pursue the road of a patent application. Our large entity filers are our larger businesses, and this is kind of the starting point for our fees. However, if you are entitled to a small entity or a micro entity discount, I strongly encourage you to investigate it and to also apply for it. The small entity discount can be taken if you are a small entity, is defined by the Small Business Administration, a small business, and can pay fees reduced by 50%. If you are a micro entity, and we're going to give you some specifics on if you qualify to be a micro entity, you can pay fees reduced by 75%. So certainly if you're entitled to a discount, I encourage you to look at it because it is going to be important that you claim that entity discount right up front because you want to pay those reduced fees from the very beginning. The other thing I'd like you to take away from this initial conversation about patent fees is the costs. Oftentimes you hear people say, I can't seek a patent, I can't go for a patent because patents are too expensive. And we appreciate and understand that seeking intellectual property protection, particularly a patent, is an expensive endeavor. Now, the fees to the US Patent and Trademark Office are actually the cheapest intellectual property office globally. So generally, the fees that are incurred by an inventor, by an innovator seeking patent protection are the fees that are charged by the patent attorney or patent agent who is providing assistance. Now, I don't say that to throw our patent attorneys or patent agents under the bus by any means, because they provide a valuable assistance. One is not required to have a patent attorney or a patent agent when applying for a patent and prosecuting a patent application. However, it is strongly encouraged. Seeking a patent is a complicated process, and that is because you are seeking a property right from the federal government, and it is a process which has a lot of format, it has a lot of formalities, and it has a lot of back and forth between the US Patent and Trademark Office and the applicant. And in the case of an applicant having a patent attorney or patent agent with their patent agent or patent attorney. So again, you're not required to have a patent attorney or patent agent, but we strongly encourage you to do so. It's just going to make the process that much easier and perhaps that much more smoother as well. As I said, small entity discounts are 50%, micro entity discounts are 75%. So it's important to know the different qualifying factors for each of these. Now, if you do want to apply for the microentity discount because you meet these criteria, recognize that you have to file a statement saying that you qualify. You have to file a certification statement, and you can find that form on our website. So I want to bring to your attention that there are discounts available because it's important to know. In certain instances, people are in a situation where they need to get their patent rights fast. They need to get them quickly. We do have a system, an initiative in place called Track 1 Prioritized Examination, where if you participate in this program for an additional fee, we can provide you a final determination in 1 year or less. Some of these patents have issued in as little as 5 months. Now, with that said, I do want to put into larger context what the basic timeline is, because oftentimes that's a frustrating part of seeking a patent as well. On average, right now, if you were to file for a utility patent today, you would get a first communication from the US Patent and Trademark Office in give or take about 14 months. You would arrive at a final determination of whether or not you are getting a patent in approximately 2 years, and that's 2 years from the date of filing. So keep in mind, if that is too much time because you either need to go to the marketplace or your competitor is out there in the marketplace, so you need your patent quickly, think about using Track 1. And as you can see for our large entity filers, it's 4,000, small entity 2,000, micro entity 1,000. So preparing and submitting your application. As I said, filing a patent application is complicated because patents have a specific form and format. Not only are there fees, but there are different forms that have to be filed and the format of the application itself. Here are 4 basic parts of the patent application: the abstract, which is sort of a short summary, 250 words or less; the written description. This is where you have to provide with specificity how to make and use your invention. Drawings are required if your invention can be depicted in drawings, and of course, 1 or more claims. Now, there's going to be a great deal about claims and patent application drafting in upcoming portions of this collaborative webinar series, but leave it to say that the claims are the name of the game. Oftentimes, when individuals look at your patent and want to know about your invention, they're going to start with the claims, because the claims really form the metes and bounds of what your invention is and what you have protected with your patent. Now, you don't want your claims to be too specific because people that can then invent around them. You don't want them to be too general because then the US Patent and Trademark Office will not issue a patent because you have covered more subject matter than you're entitled to. You want them to be right in that sweet spot in the middle, and that's where a patent attorney or patent agent really earns their bread and butter, is in drafting patent claims. As you can see from this example of what we call dependent claims, there are independent and dependent claims. Here's a great example of how claim language is just unique language. It's different than any other language in the world, and it is not the way that you and I talk. Looking at these dependent claims, you can see the invention is a headgear apparatus. Now, is that a hat? Is that hard to say? We don't have enough information here, but it is a headgear apparatus, as in Claim 1, wherein said eye shield member is adjustable with respect to said headband member. Claim language is very technical language. So again, the great benefit to having a good patent attorney or patent agent becomes very obvious when drafting your patent claims. So you're going to want to file your application using our current electronic filing system, EFS Web, or we are transitioning to our DocX system. So if you're just getting ready to file a first time, I would encourage you to begin using our DocX system, because it will ultimately be replacing our EFS Web system. We have a number of classes on our website available right now to learn more about DocX filing. Our Electronic Business Center is also there to help you along the way as you work with us in filing your electronic patent application. So let's say you actually have your patent application filed, you've got your foot in the door. What comes next? Now, keep in mind, you are going to be working with an examiner on that non-provisional patent application, not the provisional patent application, but the non-provisional patent application. What I'd like your takeaway from this slide to be is that it is a process of communication and collaboration with the US Patent and Trademark Office. You are going to be, as the applicant, you are going to be working with the examiner, and there's going to be a number of back and forths in writing. You may receive some rejections or objections. but you're also going to have the opportunity to supply amendments and arguments. And hopefully throughout that process, what the result is going to be is you arriving at a US patent. So what is the role of a patent examiner? And keep in mind, again, I said we have over 8,000 of them. They are trained engineers and scientists. They pick up your patent application. They understand it because they are trained in the technology. They search for prior art meaning patents, published patent applications, non-patent literature, trade publications, websites, anything that is published and publicly available that is pertinent to the patentability of your invention is what they are going to look for. That is what prior art is. They're going to evaluate the claims, and then they're going to write to you. They're going to write an office action to describe to you what they have found, and that begins the back and forth process. I do strongly encourage holding an interview with your patent examiner so you can make sure that you're not two ships passing in the night, but you're seeing things the same way. You're seeing things eye to eye. What are your statutory hurdles in that examination process? One, we've already talked a little bit about, is your invention patent eligible? Does it fall into one of those classes of invention for which we issue patents? But then the examiner is also going to look, this goes to that prior art conversation, is your invention new? Has it ever been invented before? Is it non-obvious, meaning is your invention an obvious variation on existing inventions? Are the claims written clearly? We do have a requirement that they be clearly written, again, with such specificity that others can make and use your invention. And again, can a skilled technician appreciate and reproduce your invention? So ultimately, what we hope is you are going to arrive at is a US patent arriving on your doorstep. And here's an example of US patent number 10 million, which issued just a few short years ago. So maintaining your patent, enforcement is one of the most challenging parts. So you've got the patent, what now? Well, it is now out of the hands of the US Patent and Trademark Office, and enforcement falls to you, the owner. So this can be challenging. When you are seeking a patent, think about whether you have the ability to enforce your patent if you receive one. Because this is enforcing it against others who may try and step into your space, who may infringe upon your technology, or who may outright copy your technology. Do you have the financial means and wherewithal to enforce your patent? There are some government resources available, stop fakes and custom and border protection. And I've got a couple quick slides that you can take a look at there on those. As I mentioned, I do want to hit very quickly some resources just to bring them to your attention, and this will give you an opportunity to go back and look at them later in greater depth. And most of them, it's material that is available on our website. If you look at our website, you'll see that there's a top toolbar of patents, trademarks, IP policy, learning, and resources. I strongly encourage for people to start at the Learning and Resources pull-down tab. In this image here, we are looking at the patents introductory page. Great deal of information for those of you who are getting started in patents and trying to pursue a patent. Startup resources. This is available under our Learning and Resources pull-down tab, and a great place for someone who is getting started with a startup and wants to know what they should be considering with respect to protecting their intellectual property. Patents for startups, trademarks, startup assistance, and current events. We do, like our Electronic Business Center, have an Inventors Assistance Center. They welcome your calls Monday through Friday, 8:30 to 8, and no question is too hard or too silly, so please hit them up with your best questions. This slide just provides to you what they can provide and what they cannot. One of the things that they cannot provide is legal advice. This slide provides a number of links, just again to help you in your entrance into our website. This is a snapshot of our uspto.gov website, and I just call to your attention again that Learning and Resources pull-down tab that's on the top toolbar, and I would also call to your attention USPTO in your region, and that's where you can find resources that are directly available to you in your region. My team and I are located in the USPTO headquarters, which is in Alexandria, Virginia. We encourage you to visit us there once the offices have reopened. We also have a presence in Detroit, Denver, Dallas, and San Jose. That's where our regional offices are provided. This is a snapshot of our Alexandria campus, and again, we welcome you to visit us when the buildings reopen. We also house the National Inventors Hall of Fame Museum on our campus in Alexandria, Virginia. As I mentioned, the Find Help in Your Area page, here's a quick glimpse at the South Carolina page. And if one were to expand all of those drop-down menus, you would find a reference to the South Carolina Pro Bono program, which is actually served by the Georgia Patents Pro Bono program. There are also law school clinics at North Carolina Central University School of Law. And again, we mentioned the PTRC that is located at Clemson University. And you do have the Inventors Network of the Carolinas available to you in your area. The USPTO has a YouTube channel where we have a number of training videos positioned, either pre-recorded from past events or recorded just to be provided on this YouTube channel. We have subscriptions that you can sign up for. These drop into your box when we only have something important to say. Even as an employee, I have signed up for these subscriptions because it keeps me abreast of what the current things are happening in patents, trademarks, copyrights, and across the agency. So I strongly encourage them. We will not spam you, and we will not give away your email address. As I mentioned, we do have events taking place every day of the week, Monday through Friday, on a wide variety of topics. How to protect your IP in China, trademark boot camp, path to a patent, similar to what we're doing today. These classes in general are all free and offered by the U.S. Patent and Trademark Office and experts there at the USPTO. Some of the programming is collaborative programming, but the majority of it you'll find there on the USPTO events page is offered solely by the USPTO. We've already talked about our patent and trademark resource centers. I encourage you to seek out the patent and trademark librarian there at the R.M. Cooper Library at Clemson University. Talking about events coming up, just to give you a snapshot into some of the things my team and I have going, we have a June history series occurring every Wednesday in June from 3 to 4 p.m. Tomorrow's program in our Hand of History, Mind of the Inventor series is going to feature Paul Israel, who is the editor of the Edison papers at Rutgers University, and his topic is Invent Like Edison. I think it's going to be really engaging. We are also having a career chat in collaboration with the National Academy of Inventors because, as I mentioned, we are hiring hundreds of patent examiners right now and are looking for people to join our team. Invention Con, our annual inventors event, is coming up August 18th through 20th, and more information will be coming available on our website here very shortly. With that, just to identify, there's a glossary of patent terms for your use, and I encourage you to, again, reach out to me by email, reach out to me by LinkedIn, and I am going to stop sharing my screen so we can take questions. I'm glad we've reserved a little bit of time. I know I've been doing all the talking, but now I'd love to hear from some of our audience members and hear their questions.
Well, Elizabeth, I can tell you that I have just gotten a text from someone who I know is a patent agent and said, you know, wow, Elizabeth is great. She is perfect. She is knowledgeable. She is clear, and she is so uplifting. And so thank you for this great information. And yes, we do have a couple of questions. Question for you. Do examiners consider an interview as an unwelcome time drain, and does it reduce their point-based reward system?
Wow, that's a great question, and that sounds like it's coming from an insider. No, speaking from my experience as an examiner and still working with our patent corps regularly, for the majority of our examiners love an interview because it provides them with unique insights to not only the inventor, but to the invention. Because in reading a patent application, oftentimes there can be a misunderstanding, either on the part of the examiner or perhaps on the part of the attorney. Perhaps the attorney hasn't described the invention with the necessary specificity, or perhaps the patent examiner has misapplied prior art. An interview is really the best way for there to be a meeting of the minds. So no, while examiners do have a very robust production schedule, They do have set hours for examining patent applications. They are strongly encouraged and incentivized to also host examiner interviews. Again, knowing that there is such a great opportunity to clarify issues. In fact, those applications that have an examiner interview in them have been shown to be more likely to receive an issued patent because there's been a resolution of issues.
Great answer. And are there any other questions? There is one coming in. Could you please say more about the accelerated examination process that you referred to in your presentation?
Certainly, I'd be happy to. So Track One is a program we've now had in place a number of years, and we've kept it in place because it has been so successful. Each year we have limited the number of applications, and over the last few years we've actually had to increase the number of applications being allowed into that program because it has been so successful. The Track One program, again, for an additional fee, the U.S. Patent and Trademark Office will accelerate examination of your application. Now, the additional fee pays for the additional resources that are necessary to accelerate the process. Now, one word of caution I would say with respect to Track One is it also puts you, the applicant, though, on an accelerated schedule. On average, when one has filed a patent application, the period for response is generally 30 days, and you can buy additional time periods. Oftentimes, the time periods can extend to 3 months or even 6 months, depending. Now, with Track One, you as the applicant, just like we as the U.S. Patent and Trademark Office, you are committing to reduced response times. So for the majority of your responses to the office, you only have 30 days in which to respond. That's how we can, in fact, issue patents in as little as 5 months, because we've cut out the fat, so to speak. We've cut out any wiggle room. So, and there's some other requirements as well, but it's a program that's been used very successfully by a large number of our applicants. And in fact, we instituted a Track One type of system for COVID applications. And for COVID applications being filed by small and micro entities, we in fact waived the fee because we wanted to accelerate those technologies coming in, being examined, and issuing as patents so as to help address this pandemic.
Got another question. If you are 65 or over, can you get an acceleration of the process?
Another great question, and it sounds like from another, perhaps one of our insider, and I appreciate them calling that out. So we do have something called a petition to make special, which is for members, stakeholders, applicants who are 65 or older, and it comes without a fee. So by simply just filing that petition to make special, and it can be filed electronically, one can receive accelerated examination.
Well, I'm going to wrap up here, but the comment has been made that there are a couple of interesting things like Tinker Toys and Etch-a-Sketches that are behind you. Are those kind of an example of demonstration antiques that have come along the way?
Well, that's a very, someone who's got a very good eye. Interestingly enough, I do love vintage Americana, and part of that results from the fact that I collect patent models. Now, when one files a patent application today, one is no longer required to file a model, a working model, but it used to be up until the 1880s. So from 1790 to 1880, our applicants used to have to file a working model. And these models were beautiful works of art, miniatures. They could be no larger than 12 by 12. But so, yes, the toys and games are all part of my vintage Americana that is my office, my home away from home office. So a very observant observer.
Well, I think you've had that throughout your entire presentation, Elizabeth. I want to tell you that I think we've had a record number of people on this webinar.
Fantastic.
Thrilled with your input, and I especially need to thank you and your team for what you do. I also want to thank the law firm of Kim and Leahy And a person behind the scenes that you don't see, Kelsey Davis, who is our SCRA communications manager, put all this together and enable this to happen, and we'll pull together the recording and get the presentation available to everyone. We'll give you a heads up. Our next webinar will be on June 17th. It will be on growth capital and crowdfunding. And then the next installation in this series will be on July 8th and will be on patent searches. So with that, again, Elizabeth, thank you so much for your time, for your energy, for your enthusiasm, and for just sharing so much today that really opened our eyes to what sometimes is considered kind of a black box, what really goes on. You really dissected it well and made it very user-friendly. We thank you so much for your time and what you do as well.
Thank you, Steve. It was a pleasure being here with you today and with your audience. The Eastern Regional Outreach Office is here to help each and every one of you to protect your intellectual property, and we look forward to further webinars and further collaborations. Thank you so much.
Absolutely, count on that. And thanks to everyone that has joined us. Have a good day, have a good week, and we will see you on June 17th and July 8th. Elizabeth, thank you again.
Take care.